0708. On for a review hearing. And I did note that I received the GAL report in this case. All parties received Ms. Day's report.
Yes, Your Honor.
Your Honor, I received it this morning.
Okay.
So that's, Your Honor, that was emailed out to both parties at the same time, and I have confirmation receipt that that was sent out timely. I realized that Ms. Dow indicated that she hadn't received it, so I mailed it 2 additional times, but it was mailed out to all the parties last week.
Okay. And at this point, is there anything that we need to address today?
Well, yes, Your Honor, had set this matter over for review to determine, one, if we had received the final report, and to determine if Mr. Gilman had complied with your requirements from our last hearing, which I think was September 16th, regarding his ongoing efforts it was September 26th. As far as his ongoing efforts to engage in services pending the evaluation from Dr. Maherg.
And Ms. Dow, is there any update to that GAL report that essentially indicated that evaluation with Dr. Maherg has not even been set up?
Your Honor, we are still on the waiting list with them. I have called pretty routinely. I have a couple of other clients who's on a waiting list with him, and they're still telling me that we're on the waiting list. Mr. Gilman has an appointment set with the VA for mental health services. He's also been trying to get an appointment with CORE for services kind of in the interim before he gets set up with the VA, which is where his services are going to be covered. He hasn't been able to schedule with them yet either. Last time we were in court, Your Honor, your primary concern was that Mr. Gilman not be holed up in his room playing video games during the gray and, traditionally depressing months of the winter. He has had a much harder time trying to make connections with public organizations. But he has, he has been spending time every day with his sister or his brother-in-law or with a couple of friends. They have bad weather gear. They go out and they ride motorcycles. They do other primarily outdoor activities. He is still trying to comply.
So is he... Well, sorry to interrupt you, Ms. McLean, okay. But I did note that I required that he attend meetings in some fashion for his mental health and log those meetings at least 3 times a week. Do we have any update on that?
No, Your Honor. He has not been able to find anything local. Again, at the time of this last hearing, your primary concern was that he not become a recluse again and risk the same sort of mental health breakdown that he had last year. He has, again, all I can say is that we're on waiting lists for Dr. Maherg for the evaluation. He has appointments scheduled with the VA. He's been trying to get appointments with CORE, and he's been making sure that he's not sitting at home.
Right. Ms. McLean?
The short answer to your question from counsel should have been no. He's done absolutely nothing because there has been no showing of any effort by him whatsoever. A quick Google search would show that there are online classes available, peer classes, specifically the Virtual Veterans Recovery online meeting groups, which meet every Tuesday online. There are peer support groups online for veterans, including veterans suffering from PTSD, that are directly available on the VA's website. We have the Cowlitz County Veterans Service Center here over on First Street. He certainly could have volunteered there. They're open pretty much 5 days a week. They were actually open 2 Saturdays ago for a program put on by the Cowlitz Wahkiakum Legal Aid Program, where he could have volunteered. We have the VFW, we have the American Legion, the Elks and Eagles, as well as Heaven, have all been offering various activities for veterans in this community. He has made absolutely no effort, which is hugely concerning. What is also hugely concerning is that he states directly in his declaration that we received, and this is on the very first page of his declaration, which is identified about petitioner's concerns and claims regarding my firearms. He claims under penalty of perjury that he has not received his father's firearms. I would urge the court to go back and look at the discussion that we had on the record back on March 14th of this year. The clerk's notes, and this is on page 2 of those clerk notes, clearly identifies that Mr. Gilman at 4:14 p.m. had asked the court if he could comment on the firearms restrictions that we were discussing at that time. The court provided a breakout room for Ms. Dow and Mr. Gilman, during which time they apparently discussed this firearms issue and then came back. And Ms. Dow and Mr. Gilman acknowledged that Mr. Gilman's father recently passed away and he has received his father's guns. And due to Washington law, he cannot just transfer to another party. It was at that time that I suggested that he sit those guns with Gator's guns until it could be determined what should happen with those firearms, because there was a concern about him having access to firearms during his residential time with the child, and you ordered him that he was not allowed to access firearms. Now he claims he's never had those firearms, which is directly contrary to what he told his attorney and what was presented to this court in open court. That is concerning. Clearly, he is minimum Jim. He's doing absolutely the bare minimum. And quite frankly, when it comes to his mental health, it's nothing, because he doesn't want to address that issue. We do think that the court, and again, this has been an ongoing review relative to our motion that we filed the first part of this year, where we asked the court to address these concerns. You have Ms. Day's report now that verifies that the child is getting physically ill during her father's visitation. He acknowledges the child is getting physically ill. She's throwing up. She gets so upset that she is throwing up during visits. How many 6-year-olds have you had that have come before your court that have gotten physically ill because of whatever stressor is happening during visitation consistently every time? I wouldn't want my 6-year-old to be throwing up all the time having visits with their father. So those are huge concerns, particularly when we were here on our last hearing. The court said that, and you were very stern and very clear with Mr. Gilman. You said he needs to understand this is the shot across the bow as it relates to his mental health. He either follow the court orders and take this issue seriously and address it, or you were going to address it for him. We're asking you to address it for him, and at least on a temporary basis, adopt Ms. Day's recommendations to day visits. We're asking for one 6-hour visit, either a Saturday or a Sunday every other week. My client also provided for the concerns on the Thanksgiving and Christmas that they had previously discussed about Mr. Gilman having Thanksgiving Day and Christmas Eve every year, and my client would have the child Christmas Day every year because of the child's reaction. We had proposed for those day visits to, again, be from noon to 6 p.m. And he needs to be serious about his mental health. There are copious amounts of available peer groups and classes out there for veterans, and he has done nothing. He's been online gaming, but he can't take enough time to do a Google research to address his own mental health concerns.
Your Honor, if I may, as to the gun issue, as far as I understand it, at the time his father passed away, I believe my client thought that he was going to be getting a certain amount of property from his father. I would have to confirm this with my client, but it's my understanding that at this point, there were bequests that were not what he thought they were going to be, and he doesn't have his father's guns, and he says he's not going to get them. That is all that I know about the gun issue. As far as the child and how well she is doing with him, he has not said she throws up every time she's with him. He says he understands that sometimes she gets sick to her stomach because she gets overexcited, she gets overtired. He addresses that as best that he can. The guardian ad litem has recommended not just one day on a every other weekend basis. She's recommended, and I believe Ms. Gilman requested, daytime visits on Saturday and on Sunday every other weekend. If the court feels that the overnight visits need to be reduced until we have some third-party professional reports on the state of my client's mental health, they should at least be 2 days every other weekend.
Right. Thank you, everyone. I did review Ms. Day's report, and I reviewed the minutes from the September date, and then as Ms. McLean pointed out, the March court hearing. The minutes seem pretty explicit that he was in receipt of his father's firearms. If that's not the case, that's not the case, but there's definitely some ongoing concerns. I'm glad that he's getting out and about and not isolating himself in his home. However, that's not that may have been an intent of the court, but very specifically, the court ordered 3 meetings a week to keep a log and to turn that in. We have nothing. And I would agree with Ms. McLean that there are ample opportunities. He's an online person, a gaming person. From almost everything that I've read, there are sufficient online resources for him to be able to find something to log 3 meetings a week of some sort to address these mental health concerns. I will be the first in line to say that we do not care enough for our veterans once they are out of the service, but there are resources available. I wish there were more, but there are resources available, and he needs to follow up with that. After review of the GAL report, I am going to temporarily adopt the GAL report. I am going to suspend overnights until he starts doing something. And we need to figure out the firearm issue. And I am concerned because it does, in the March hearing, excuse me, let's see.
March 14th.
March 14th hearing, there is, in the minutes, it indicates that Ms. Dow addresses the court, advises that Mr. Gilman's father recently passed away and he has received his father's guns. Due to Washington laws, he cannot just transfer them to another party. So to me, that's a pretty definitive statement that he had them in his possession and couldn't transfer them. So if that is not the case, then he needs to show proof to the court that he does not have those firearms and let us know where those are. I am going to adopt the GAL report, which is different than Ms. Gilman's request, but it does suspend any overnight visits. So it allows for, and here's what I'm going to do. The Ms. Day's recommendation is for every other week, a Saturday and a Sunday visit. And those are, she lists them from 9 until 6. I'm going to do them from 9 to 4 p.m. every other Saturday and Sunday day visit. And it sounds like the parties had an agreement different than what the GAL recommended for holidays, and that would be the father having Thanksgiving from noon to 6 and Christmas Eve from noon to 6.
And then my client would have Christmas Day.
Correct.
And then the request, so is the court adopting then the balance that includes the statements from the property owners about the weapons restrictions and whatnot?
I do think that that's appropriate, and that should be an easy, I'm assuming that Mr. Gilman has been honest with the court, and that hasn't been happening. So that should be an easy ask for the folks that are in the home that have the where the safe is housed. So yes.
Is the court still requiring Mr. Gilman to do the 3 meetings per week?
Yes.
And Your Honor, if he can show some sort of proof that he is complying with 3 contacts of some sort a week, can we then review the status of the parenting schedule?
I think he needs to address his underlying mental health issues. I mean, clearly that's a concern.
If he gets 3 meetings in this week, we're not reviewing it on Tuesday to reinstate overnights. I think he needs to make a showing that he's taking the courts seriously, the situation seriously. And really that's kind of the concern, because it doesn't appear that a lot of changes have been made. And if he doesn't take care of himself, he's not going to be able to take care of his child. I mean, that's really just where we're at.
I understand, Your Honor. So,
but yes, if we get several weeks of compliance and he's doing everything he needs, we have an appointment with Dr. Maharg finally set, and he's starting to address these issues that we've been trying to tackle the last 6 months. I'm, of course, willing to reconsider the temporary plan. But at this point, I'm going to adopt the GAL's recommendation, apart from the time difference that I indicated and the holiday difference that it sounds like the parties already agreed upon.
Presentation. I'm
not here next Tuesday, so beyond that, and I would ask the clerk to weigh in if there's anything. I don't think I have any closed dockets upcoming. We're at 16 for the 28th.
Do you want to do the
7 for the 5th? We could do Friday the 1st. No, we can't do the 1st December. I'm not here that day. So
I can do the 28th.
I can do the 28th.
Thank you, Mr. Wanzer. Okay. Good afternoon. 28th at 1 p.m. And this is on for motion to compel.
Yeah.
And Mr. Ignacio, I see there was a declaration of an affidavit of service. I don't see any response.
There's no response. It's been 134 days and there's still no response.
Right. Mr. Ignacio?
Yes, Your Honor. We need a discovery conference in this, as opposed to me filing competing motions to compel. Mr. Wanzer, I mean, I have his answers to interrogatories and we asked for updates. He gave me updates yesterday to the answers, but you know,
we're not here to talk about my answers. We're here to talk about
Mr. Wanzer, we're not interrupting anyone. That's not happening. I understand your position, one at a time.
Thank you, Your Honor. We asked simple questions like provide your social security number. He objected to that. I gave him the opportunity to update that answer. Yesterday, he updated it by continuing his objection to providing his social security number. And there's other, you know, we could go through this, you know, many objections. I asked him if he was on social security and he objected, saying he didn't have, you know, any way of answering that question, and he didn't update it. I mean, you know, it's a yes, no question, and it goes on and on and on. I have, you know, all sorts of issues with regards to his. Now, with regards to our answers, he's done this motion, and you know, it's like, you know, he put in here, he asked me through my client, you know, on what day, how many days a week does Bobby DePriest stay at the house? She answers, none. He lives at the Oxford house. And he objects to that. He said, did not answer the question that was posed, evasive, no, that's an answer. You know, and his objections go on from 7 a.m. to 9 p.m. How many days a week is Bobby DePriest at 361 Warren Street? None, except once in a while, on rare occasions, he would stay the night. That's her answer. He objects to that. How many, you know, he says objection, evasive, it's non-answer. That's her answer. And so these objections to our answers go on and on and on. And yet here we are. This is, I think, the third time we've been in here on discovery. We just got his updated answers yesterday. Either I need to do a motion to compel and get these before Your Honor, or we set this for a discovery conference. On his, I think we need to go through his objections here via a discovery conference to say, what my client has answered and what still needs to be answered. But this goes on and on and on. How many nights a week, Bobby? He lives at the Oxford house. That's not an answer. Interrogatory number 7. These individuals present during the hours of 9 p.m. to 7 a.m. And her answer, my son, Bobby DePriest, and his sons, Dalen and Dalton, stay the night on rare occasions. His objection did not completely answer the question. We did, but yet here we are, motion after motion with regards to this discovery. So I'm going to ask Your Honor to take control over this situation by way of a discovery conference, or in the alternative, I'll file a motion and we can go through his objections, question by question, and this is costing my client. I mean, we're going to need an award of attorney's fees once you see his answers and his objections to our questions, and having to do a motion to compel, or even by way of a discovery conference, you'll say, yeah, these answers he's playing games.
Wasn't there a CR 26I already scheduled by Judge Scudder for October 6th?
Yes, Your Honor, we did that.
So the CR 26I on October 26th, we agreed that we would give answers on certain days. I provided my answers. He didn't provide his until yesterday.
Well, excuse me, Your Honor, but
go ahead, Ms. Ronser.
My answers were due on the 10th. They were attempted to be delivered on the 10th. His office was not open. They were there at 1 o'clock in the afternoon by my server. They were closed. They were not there. So they got delivered on Monday. As far as him saying that I didn't provide my answers, they have my social security number. They have everything that he has asked me. I have provided everything that they have asked in my paperwork. They have all that. They're the ones that are playing games here. They're not wanting to answer the questions because it's incriminating. As far as what he was saying with Mr. DePriest staying there, in her answers, it was, he's always been here. He never lives here. Sometimes he lives here. Once in a while he lives here. I have neighbors that can confirm that he's been staying there. And I asked for the information on the loan that you had me pay, the loan payments. And he said in the last court date that he had given me that information. The day after we had that court date, I emailed him, said, you have the information, please get it to me. I still haven't got that information. Haven't got the information on the checks, the bank accounts, any of that.
So it looks like in your request, so I reviewed some of this, some of it may be relevant. Some of it, frankly, I think your objections are off base a little bit. But there are some requests of missing statements.
Yes.
Looks like it's just because of the last few months that you're missing. So August 1st, 2023 to
now. There's more than
Let me finish. May 1st, 2023 to now. So it's not like you have gotten nothing. You just want an update of those financial records. Is that correct?
There was other stuff that I had asked for too that they had not provided in their first set or second set that I have asked about the checks, about the accounts. I mean, it's relevant to me that it looks like she's hiding an account somewhere, because she's not withdrawing any money out of the other accounts, and she's getting these checks, $5,000 check here, $900 some check here. They're just appearing out of nowhere.
Yeah, if I could briefly respond, one of the questions he asked was explain the type of account, star, 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 3700. We had to look that up. That's a bank thing that a bank puts on your statements. And so we answered it. This is a magnetic ink character recognition line. That's what I had to look that up because it said it's a MIC character or something like that on her statement. It's the way banks are able to identify your account. He puts in objection, did not answer the question posed. And it just goes on and on and on. He doesn't like my answers. Well, that's not appropriate for this motion. He had a first of interrogatories. We answered those. We can update bank statements if we're missing those, but
Your Honor, that number that is on there is a loan number.
No, it's not.
All right.
That is the loan number that you gave me that I had to pay. The numbers that I gave on the questions. It was what you ordered me to pay. That's all I had to go in there to pay it. I had them look up that number, and it was a loan payment that I had to pay.
Okay.
It's just a number of a loan payment.
Clearly, there's issues here. I can't sort through all of this on the docket. I'm inclined to grant the motion to compel, but you need to understand, Mr. Wanzer, but that a lot of the answers that they've provided are answers. Your objections are not based in any legal reasoning to object. So if there are things that you feel are inconsistent with one another, that's something that you could potentially use in a trial setting, but you can't just keep objecting to the answer until the answer is what you want the answer to be. So okay. There's, if there are financial documents, it sounds like they're willing to provide updates and financial documents. Some of these questions about from 7 a.m. to 9 p.m., who's in your house on a daily basis, it appears that they're trying to answer those. If you feel that those are inconsistent or are wrong, or you have proof otherwise, that's something you can use in your trial potentially. That's not something that you can just keep hammering them for updates to get an answer that, comports with whatever you think the truth is. The financial statements clearly are a concern. It sounds like Mr. Anagnostou is not objecting to giving you updates on the financial statements. As to this magical number that Mr. Anagnostou had to look up that I have never heard of myself either, that there's a disagreement about, if that's to a loan, and I know that there was a loan specifically that you discussed last week, and I want to say I just saw it in here. What is the name of the loan, Mr. Wanzer?
That's what I don't know.
You list the name of the loan, but you don't know what the loan is for. Let me see. Sorry, I just had it and then I scrolled away from it. And now I can't find it. Mr. Anagnostou, in order to supplement what you feel is appropriate to supplement and finish the requests that you have after what you just received yesterday, how much time do you think you would need?
2 weeks.
I'm not trying to interrupt you here, but the information on that loan that he says that he had already given me that I asked for after the last court date is the loan that you had ordered me to pay. That was the one I was asking about. That is that 00. I'm looking for it here.
As I recall, that's part of
ink character.
Yeah, that's the magnetic ink line that he says that they don't have anything about, know anything about. That was the numbers that I had of the loan that the bank gave me. The 7 is XXXXX70, which is the loan that you had me take over the payments on, and it is a loan through Fiber Credit Union.
That's identified.
Why would I just make payments if it's not a loan on that? I have the receipts for the payments that I made, every payment that I made, but I don't know what that loan was for. What was that loan for? Was it for her or was it for Bobby?
You're not, I don't have the answer to that question.
And it's part of the temporary orders, Your Honor. Your Honor ordered, it's in declarations as to, in my client's financial statement, you ordered him to pay, I think, the house payment and one of the debts, and she had to pay some other debts, but that's all part of the temporary orders. They were all identified.
That's great. I'm saying that a lot of times when we break those down, I don't know what exactly the loan was for. I just know there's a loan of X amount of money. The court doesn't always get that information until we get to trial. So I guess
that's what I was asking for, as to what that was for. I
would assume that if that hasn't already been given to you, which it sounds like it has not, that Mr. Anagnostou and his client would be able to answer that question. So that should be answered. I don't know if another CR 26I is appropriate in this case, but clearly there's a lot of communication issues, and it sounds like they're agreed is some supplemental information that needs to be exchanged. I don't know, Mr. Anagnostou, if you even had an opportunity to review everything that you received yesterday from Mr. Wanzer. I'm inclined to set this to the 5th of December at 1 p.m. I'm going to ask the parties to have a conversation about exactly what is left. Mr. Wanzer, I'm going to let you know that some of your objections, I am not going to go through them line by line, but some of your objections are unfounded. So there's some of this information that's going to be what it is. Financially speaking, all of those things should be provided. So any information about what an account is that you're not aware of, what an account is, what a loan is, who it's through, what it's for, that should be, should be provided. Updated account information that's requested from either party should be provided. Any information that you feel that they already have that you're saying, I'm not providing to you again, you need to provide. If they already have it, there's no harm in providing it again. Let's stop with the gamesmanship and the back and forth so we can resolve this matter. The 5th of December at 1:00 p.m. If there's any additional issues or motions, please have them filed so they're ready for the court to review before the 5th, and we can try to hammer this out on that date. So the motion to compel, I'm not dismissing it. So we'll just carry that over to the 5th. If there's anything remaining, we'll deal with it at that point.
Okay.
Very good.
All right. Good
Thank
luck.
you.
Matt is ready, Judge.
Did you submit something?
I did. We filed a proposed order after last week's hearing. It looks like that went out, I believe, on the 9th.
Does the clerk have something? I see that now in Odyssey that was done. Was that on the 9th? Mr. Zanny, you submitted it?
Correct.
All right. The only order I got today from the clerk's office is in the Krebling and Hogan matter. Or Hagen.
That would be settled pursuant to Mr. Baldwin's request, but there should have been close in time. This is one that's a quick turnaround. We were just before you. I think it was last week. You gave us the order. We asked for a quick turnaround specifically, and then of course with the 3-day holiday, it tends to complicate things a little bit. I will say that a copy of that order went to Mr. Rapp. Looking at the proof of service on November 9th. I'm assuming we filed it that same day. So you have it. It should be there. I'm happy to run over another bench copy if necessary, but we have not, to the best of my knowledge, heard from Mr. Rapp since court last week. I didn't get any objections to the proposed order, but I also didn't get any authorization to enter pro se either. Well, it looks like he's present. Good.
Mr. Rapp, are you present?
Yes, I am, Your Honor.
And did you receive a copy of that proposed order?
Yes, I received the document that he sent me an email, I took copies. I took it to the Social Security office. They told me they couldn't do nothing because it wasn't signed by the judge.
Well, I'm gonna sign it as soon as I have a copy in front of me. So, and then you'll be able to get it from the clerk's office. And then I appreciate you trying to be proactive. We'll get that signed. And we'll make sure that you can get a copy of that, hopefully by the end of this week, and then get that taken care of.
All right. Well, he's just going to send it to Mr. Zandy, and he can email it, and I can take copies and take it to the Social Security office.
Assuming you don't need either a certified copy, we can do it that route. You may need a certified copy, which you would have to pick up on your own from the clerk's office.
Okay.
Okay. But we'll all,
when I get,
go ahead.
So when you get this signed, I'll just go to the clerk's office and ask for the document.
Yes. You give them your name and the type of case it is, and they'll be able to look it up and provide that to you. You may have to pay a small fee for a certified copy. I'm assuming this order is around here somewhere. So what I would do, Mr. Rapp, is I would call the clerk's office maybe tomorrow afternoon to see if they have a signed copy of it, so you don't waste a trip over here. After they let you know they have it, you can come in, grab it, and then take it over to Social Security.
All right. Thank you.
All right. Thank you, Mr. Rapp.
You want another fresh copy of that in case the clerk's office can't find that, or are we confident that they've got it? Just haven't circulated back to your chambers yet?
I think, is it Tiffany that I have in the courtroom? I'm going on.
Yes. It looks like we have a note that says that we have it. It was entered at the very end of the day on the 9th, so it may just not have made it back to you. I'm not sure.
Okay. Mr. Zandy, I will have somebody contact you this afternoon if we don't find it and I can't sign it this afternoon, so we can get it turned around.
Okay, thank you.
Thank you.
Tina Day here at Guardian Ad Litem.
Good afternoon.
Caitlin Dennis on behalf of Miss Duke.
All right, good afternoon.
Hello, Your Honor, Vice Stearns.
Good afternoon. All right, we are here to review the GAL report. It does appear, at least that I received, and the court received a copy of that GAL report just last week, or excuse me, on the 2nd. I don't even know, that might be 2 weeks ago at this point. Has everyone else received a copy of Ms. Day's report?
Yes, Your Honor.
Yes, by email.
Okay. Anything that we need to address today beyond that?
There are a couple issues. So I would like to request a continuance as the report was submitted recently, and I requested Ms. Day's notes and I have not received them to go over them or submit a proper response yet.
Your Honor, we do plan to be filing a formal motion. Oh,
sorry.
I don't know why. Is that me or you?
No, I think it was Mr. Stearns, and I just Mr. Stearns muted you because of the loud noise, but we'll get you unmuted here in a second. Sorry, go ahead.
Okay. So we will be filing a formal motion for temporary orders to get a parenting plan and child support in place. We just haven't had time given when we received the GAL report and then the holiday last week. I guess my client would like the court to adopt the recommendations in the interim. We plan to have that on the docket, hopefully by December 12th, to have a full hearing. But given the concerns raised by the GAL, I think it's important that, the court do kind of an interim order to put the kids in mom's house, given the emotional and, use of conflict and the emotional abuse of the kids that's going on in dad's house.
When did we enter the first temporary parenting plan?
They actually don't have a first temporary parenting plan. There is kind of a Band-Aid order that we put in place when the GAL was appointed, and I cannot remember that date. It was several months ago, that basically said they would continue the status quo. because these are parties who have been separated for several years. They're just now filing for divorce. So this is actually going to be an initial temporary parenting plan that we're putting in place.
All right. I see that. Looks like Commissioner Nelson, didn't, at request for temporary orders, did not enter any temporary orders and appointed a GAL. That's okay. And Mr. Stearns, I guess my understanding from your request is that you are going to want to file a motion on your behalf, I'm assuming, for temporary parenting plan or something along those lines.
Your Honor, I was going to request a continuance because the GAL reported so recently. I requested her notes to go over and I haven't received those yet, so I haven't been able to submit a proper response because of most of what they're saying is incorrect.
Okay, I'm not asking about your, okay. I'm not asking about your continuance request. I'm asking what you want a continuance for. So are you intending to file a motion for a temporary parenting plan, or what are you planning on doing? And you're going to have to unmute again because we're getting a lot of really loud feedback from you.
Yes, that's what I would be doing, is filing a motion for a temporary parenting plan.
Right. So I'm going to mute you again because I don't know what's happening there. Couple different concerns. We are on for just a review of the GAL report. I don't generally like to make broad changes to parenting plans just based on an oral motion to adopt a GAL report because there's generally a lot more going on here. I will note, and it's not to say that I haven't done that or wouldn't do that. I will note that there were some pretty significant concerns that Ms. Day expressed in the report. Sounds as though Mr. Stearns feels pretty strongly that those are either unfounded, misunderstood, or incorrect. And I don't want to put words in his mouth, but based on his previous comment, that's my take on his position. Since this has been status quo for so long, I'm just going to ask Ms. Day and then I allow either party to follow up. If there's going to be within the next month a motion to review a temporary parenting plan, I guess, are your concerns significant enough that you think action needs to be taken now, or status quo until both parties have an opportunity to submit some additional information would be acceptable? I know that's kind of a tough question, but
it is. My concerns are pretty significant, but I think if this was going to be heard within the next, say, 30 days, I think that's not an unreasonable thing to have it wait, and a reasonable time to make a change, if there is one warranted, after a hearing, would be Christmas break, with the caveat that the children not necessarily change schools. I don't think that that's necessarily a requirement, although I didn't investigate that part of it because they've maintained the children in the Woodland School District, regardless of where mom lived. My one concern would be, if we're going to put it over for 30 days, is that be kind of a hard date, but also that all the parties are restricted and their partners are restricted from discussing this with the children. One of the main issues in this case is kind of a belief that the children have a right to choose where they live. They've been overinformed about literally every single piece of this process. And certainly the older child is very, very concerned about what's going to happen to dad and what's going to happen if mom takes custody away, which is what he's been told is in the process, is that mom is trying to take custody from dad and that he will never see his father again. And I don't know why he has that belief, but that's clearly his belief. And so, and then just the level of hostility that is occurring at the exchanges, the information where the children are being told they can't call mother mom, that they have to call the partner mom. And I don't think they've been separated a long time. And I think Miss Jude has been a part of their life as a parent. That is not the issue. The issue is restricting them and giving the children the information that mother is so terrible she doesn't even want a name. And I think that's incredibly harmful. So if the court is inclined to wait, I think 30 days would be the farthest out I would be comfortable waiting. I want to also add, though, that Mr. Stearns did ask for a copy of my file. I have been in trial for the last 3 weeks. It will take me some time to make that copy and provide that to both the parties, which I will do as quickly as possible. But with the holidays upon us, and I have another trial coming up the following week after the holiday, that may be very difficult. And I don't know that I can provide all of that information in a timely fashion that won't ask for another continuance. I provided this report on November 2nd to all the parties, so that was 12 days ago. And so I just want the court to have all that information.
All right. I appreciate that. Ms. Dennis, any questions for Ms. Day based on that information?
I guess I believe I can get this on within 30 days. I would agree that we definitely need to get this heard within that time frame. If I don't know if the court is not going to change the actual parenting plan at this point, I would ask that at the very least we change the transfers to either curbside or a neutral location starting now, where neither party is speaking to each other, no one's yelling, because there have been continuing issues even since we received this report. So I think that's important that we get the kids out of that conflict as soon as possible. And then I guess the other question would be if the court would be willing to order father to obtain the mental health evaluation, or at least start that process. I know that might be something you want to wait for temporary orders, but it's also, in my experience, there's quite long wait lists for those evaluations right now. And sometimes people are looking several months out just to get in with a provider.
All right. Mr. Stearns, anything that you want to, any final comments you would like to add? And you're muted again, so you'll need to unmute.
Yeah, there are a lot of comments. I would like to address some of the things that were said. I'm not forcing the boys to call anybody anything. The pickups and drop-offs I recommended be done at the school, but my ex refused, so she comes to my house and we videotape every session, and we're not the ones being hostile. There's so much that's incorrect, and I don't know why I'm being made out to be an angry person. That's one of the main issues. I just need time to respond appropriately.
Did you provide those? Did you provide those videos? I don't know what's going on, Mr. Stearns, but I'm not going to be able to keep you unmuted if that background noise continues.
I'm sorry, I don't know what noise you're talking about. I'm trying to
figure
out what it is.
Pretty loud and unable. I don't think the record's going to be able to pick up a lot of the interaction based on some of that. Yeah. Did you provide any of the video footage where you're normal and the other party is supposedly isn't to the GAL if you're recording everything?
Yes, we tried to email them that information. We're not sure if they got it or not.
Okay. All right. I'm gonna. Here's right now. The exchanges are happening at the home of the parties.
At my apartment, she drops them off, and then I drop them off at the school. So I never go to her home.
Okay, and you're and that's in Woodland, correct?
Yes. And
I'm sorry, Ms. Dennis, where were you indicating that you're requesting the drop-offs happen?
I mean, I think that it's okay to continue at each party's home, provided they're curbside and the parents are staying inside their respective homes and the kids are walking back and forth. I think that we need no one videotaping, no one yelling, no one following mom around with a video recorder in front of the kids. I know father pushed blame on the kids saying, oh, the kids asked for us to record this. I mean, that's completely inappropriate. And that needs to stop immediately. These kids are old enough. They can, pack a bag, walk from the car to the other person's house without a parent even getting out of the car or making any comments or anything like that.
Okay, I don't see how it's inappropriate when the hostility comes from my ex, and that's why my boys request the video.
Right. And
okay, so here's what's going to happen. I want to set this for the 5th. So I'm going to ask that everybody put in their information for their request for a parenting plan by the 5th. Mr. Stearns, I understand that means you may not have all of Ms. Day's notes, but you have pretty lengthy summary of all the information that she went through. And because I think we do need to address this sooner rather than later, I am going to ask that there be no interaction between the parties at exchanges. So we're dealing with a 12-year-old and a nearly 8-year-old. They can have their bags packed, walk from the apartment to the car without any interaction, with no other parties leaving the apartment and interacting with the other party. So that shouldn't be a problem. And then if school is the other drop-off, that they've heard no issues about the school being a drop-off, or the school drop-off being an issue. So no interaction. Parents and stepmoms can stay in the apartment when the exchanges happen, period. I think based on the recommendations, there is some concerns that the court has, and Mr. Stearns, I think looking into a place where you can get an evaluation as recommended by Ms. Day in the evaluation is probably a good idea to start looking for options there. I'm not going to order that at this point, but basically that is an indicator that it very likely could be ordered in the near future. And I think I'm still talking. I think all parties need to refrain from having any discussions with these children about anything that has to do with this process. That is not beneficial for those children. That is not beneficial to either party's position in this case. And it's not beneficial to the likely outcome of this case in any way whatsoever. I understand that they may have a lot of questions and concerns, but this should not be discussed. There should be no disparaging comments about the other party to the children or anyone else in the children's presence. That should never have been happening. So I am concerned that it very clearly appears that these children have way more information about the ins and outs of this case than they should have. And that's frankly just no good can come from that, to be very honest. So, and then I'm going to hold the party's feet to the fire and set this to the 5th at 1 p.m. for temporary orders.
Okay, and then can we get an interim deadline in there for any, like, when we want to exchange our materials, since that's kind of a shortened timeline? Like maybe we file our motions by the 21st and our responses by the 28th or something like that.
How about the 22nd and the 29th?
Okay.
And that puts us up against the wire, but I think it's still gives a little bit more time to each party to get everything organized.
Okay, thank you.
All right, good luck. We'll see you on the 5th.
Just to clarify one more thing, I think this will no recording at transfers by anyone, right?
I'm not gonna, if they're in their apartment and they want to record through the window, that's fine. It shouldn't be a thing. It shouldn't be an obnoxious, in your face, following children out to the car thing. Nobody should be following the children out to the car. They obviously, the dad can watch them get to the car, so we make sure that they're there safely, but there should be no interaction otherwise.
Okay.
All right.
Thank you.
Question, Your Honor.
Quickly, yes.
I would like to request my ex for a mental evaluation as well, because I don't know why I'm being forced to take one when I requested it to begin with for her.
You can ask that in your temporary orders.
Okay. Awesome. Okay. Thank you.
Thank you. And I see, obviously, we have Mr. Zandy, we have Mr. Lawrence. Do we have a Clarice Green petitioner? Any reason anyone has for why she may not be present?
She's been hit and miss throughout this process, Judge. She's lives in Idaho currently. I think that's kind of reflected by Mr. Lawrence's report. We really don't have, from our position, much expectation of her at all. So I'm not entirely surprised she's not here today. But then again, my office hasn't heard from her in quite some time. So that's all I got for you.
All right. And I do note that I received the GAL report. I see that there was an affidavit of sorry. Looks like that was sent out to all the parties. I'm assuming, Mr. Zandy, you received that report?
I did.
And it appears to me that, and Mr. Lawrence, if you just want to, for the record, indicate that that was also sent to Miss Green.
It was, Your Honor, as well as Mr. Green.
All right. Based on my review of the report, it's relatively status quo, apart from ordering some or having some requests for evaluations on the petitioner. Mr. Zandy, anything that you want to address on this one today?
No, I think the findings of the GAL speak largely for themselves. I would say that they coincide with the history of this case, which was initially reported in Lewis County through the protection orders. There was at least 2 that I'm aware of that were entered against Ms. Green. And then the comments that kind of precipitated this action made by my client in his motion for temporary orders last summer, that we have very significant concern for Ms. Green. We have very significant concern for these kids, and what the GAL terms as cruelty towards them at the hands of their mother, who, you know, obviously is the person that you would hope and expect to cherish and care for her children the way that they should be. She did a heck of a lot of damage to them in a very short time prior to her leaving for Idaho, and largely been out of their lives for the better part of 3 years. So we do agree largely with Mr. Lawrence's recommendation. I would comment that a lot of what was stated and found by the GAL somewhat surpassed our expectation. And I think this is, again, a level of cruelty that isn't necessarily often seen by this court, and that's extremely sad. We need safeguards in place. I have no expectations of mother against an individual who's made no efforts to see her kids in over 3 years. Frankly, that's probably a good thing for these kids. We'll see where it goes. We'll see if she gets the help. We'll see if she does what she needs to. And ultimately, if she decides to submit, we'll see what the psychological evaluation with the parental risk assessment, that component, comes back as, and we can kind of go from there. In the meantime, these kids appear to be taken care of. I think that's evidenced by the statements that were made by my client at the onset of this case and found by Mr. Lawrence. So I think that's the positive, but we still have grave concerns about mom and what's going on in her life.
Okay. Well, at this point, this was just a review for the GAL report. We have it. Any change in orders can be noted on, and hopefully, I don't know. I'm glad that it appears that the children are in a safe spot at this point. So,
you want to adopt? You want me to put that in a temporary order? The GAL's findings and recommendation. Given that we're largely in agreement with that, I'm always somewhat. You never really know what to expect on a review here, whether you're going to make changes or not, or as to a GAL input. We have that input. I think it's probably appropriate. It dovetails with what my client initially requested back in the summer. If my memory serves correctly, Commissioner Carmi heard this initially, but we would like to adopt those recommendations as they've been requested now a couple of times. You want me to note that on for a motion, or can we do it today?
I have reviewed pretty much this entire file. I did make notes. I do see the recommendation. The notes I made are kids should remain with dad. Mom should get this psychological evaluation with parental risk component and a domestic violence evaluation, both with collateral input. And I think that is appropriate to order. And that basically that's where we're at until those things happen. If and when those things happen, then we can discuss reunification. So I'm comfortable with the front part of that, the evaluations and being collateral, and dad having custody of the children and no visitation until those 2 evaluations are complete. So if you want to submit those in a temporary order, ex parte, or we can set it on for a presentation.
I prefer the ex parte route, especially considering she's not here. If you want to track that through a formal presentation hearing on the 28th or the 5th, I would be fine with that as well. I'll either be here on the 28th in limited capacity, or I can have Ms. Bliss do it on my behalf. I'm neutral either way. There was a secondary issue. This is one that dates back again at the time of temporary orders, obviously not nearly as urgent as the matters involving the kids, but my client has kept his wife's personal belongings and effects in a storage unit at over $100 per month since she left several years ago. You want him to continue paying for that? We had asked that she come and get her stuff by a date certain, or alternatively, he could get rid of her personal property and eliminate the need for payment on a storage unit? Or do you want to hold off on that for the time being?
I'm fine addressing that right now. I think let's give her with the holidays. I'm going to be maybe a little bit generous with the time. Let's set. She's in Idaho, right? Idaho.
And she doesn't drive. She doesn't have a license. I didn't know she'd been here 4 times over the past. We've got the GAL findings, but she's been here 4 times. I don't know how she's getting over here. I can only assume it's through her mother or father, stepfather, whoever she lives with in Idaho. So she has access to get over here. I don't know how readily available that is to her. And my client would be fine if you give her the benefit of the doubt and an extended period. I don't think you would have any objection to that.
Let's give her 90 days. So how about to February 14th, 2024? If she does not pick up that those belongings, then I'm fine with the order reflecting that he's no longer obligated to maintain that storage facility.
Fair enough. And do we decide if we want a presentation date?
If you want to add it to the 28th, just as a safety precaution, I'm fine putting it on there. And then I would just ask Tiffany if we could close the 28th at that point.
Okay, very well. Thank you.
And if we get it before then, we can strike it.
Okay.
All right. Thank you very much, Mr. Lawrence and Mr. Zandy.
Thank you.
All right, we can go off the record. Thank you.